Hey, Judge. Portia, future assistant public defender on behalf of Mr. Zanzar.
What's up, Mr. Simmons?
Zanzar.
Good
Hello.
afternoon. Happy Halloween, man.
Yes, to you too.
I am good to see you, man.
Right away, this courtroom has that strange calm before the storm energy. Everybody is friendly, everybody is polite, and Judge Simpson is giving the defendant room to show he is handling his responsibilities. But in court, pleasant greetings do not erase legal pressure. This first exchange matters because it sets the tone. The defendant is asking for patience. The defense is trying to explain program involvement, and the court is clearly looking for proof, not promises, not vibes, not hallway confidence. The stakes here are simple but serious. If the defendant is claiming progress through a program, the court needs verification. That means compliance, testing, supervision, and accountability. And here is the tension. When someone walks into court hoping for good news, the judge may still test whether that hope is backed by facts. Viewers, would you trust someone's word in this position, or would you make them prove it immediately?
I hope for some good news. It's going to work. It's going to work.
Thank you, Judge.
Please.
I've spoken to my client in the hallway.
Really?
Yes, Judge.
Okay.
He's apparently involved in the LEAD program. He is in that program right now. He said Willie is the supervisor there, and APA Robbins is the contact person there.
Yes.
So we are trying to get some information from them as to how he's doing and his success to see about trying to get this situation resolved. I'd ask for a 2 or 3 week adjournment, please. Is that all that accurate?
Yes, sir.
Wow. Yes. Yes, you may. And I know council's got to figure out what's going on with you in the LEAD program and figure all of that out.
Yes.
If I sent you over for a drug test, are you testing at community corrections?
Yes.
You are?
Yes.
Okay, when's the last time you tested?
Last year.
Last year?
Yeah, it's not 2 years ago.
Okay, but you're not currently going over there?
No, not at the moment.
Okay, so let me ask you this.
Yes, sir.
If I sent you over there today, what's that test gonna look like?
I would say negative, meaning good.
Okay, so let me ask you this. Is it gonna come back negative?
Yeah, maybe. I believe so. By the power of God, I believe it's going to be awesome, man. I believe it will be good.
You said maybe it will?
No, maybe not. I believe so.
Maybe not?
I believe so.
Okay, let me ask you this. You been using anything that might show up? Now, hold on before you just out and out answer me. I need you to tell me the truth. Because if you don't, you wanted something good to happen today, but if you don't tell me the truth and something comes back, we're gonna have a problem.
This is the first major pressure point. Judge Simpson is not playing a guessing game here. He is warning the defendant in plain language that honesty matters more than a convenient answer. The judge gives him a chance to admit if anything might show up before the test happens. That is important because courts often treat dishonesty worse than the underlying problem. If a defendant says, "I'm clean," and then the test comes back positive, the issue becomes bigger than drug use. Now it becomes credibility, trust, and whether the court can rely on anything he says going forward. The defense even reinforces it. Tell the truth now, because saying no and then failing the test is a terrible courtroom strategy. This is one of those moments where the judge is basically opening an exit door from disaster, and the defendant has to decide whether to walk through it.
You're not using any drugs or narcotics. You didn't tell me you were. If you are using something, you're better to tell him now. I'm gonna say no, and it come back positive way. Okay. So if you are doing something, you should tell him. If you're not, that's fine. But tell him the truth.
Hey, Judge, nope, I am not doing no substances.
Nothing's gonna come back? It's gonna come back all clean?
Yes, sir.
Okay, so can I trust that if I pass this matter, can I trust you to get yourself over to community corrections for me?
Oh, yeah.
You know where it is?
Mhm.
You don't need me to have somebody get you over there?
No.
Because you know how my cab system works, right?
Yeah.
Yeah.
You know me, man.
Okay. All right. So what I'm going to do is I'm going to put this case aside. You get over to community corrections. We're going to do a quick order. Get it over to them. And I want you to do a drug test, okay?
Yes, sir.
All right.
Cool.
We'll see. And then you need to come back.
Okay.
Okay?
Okay.
I'm gonna walk him out and point him out to the building,
Yes.
try to help him, make sure he gets there. So you gotta go there now,
Okay.
take
You're
the
right.
test, and then come right back. Okay, all right. I'm gonna walk him out now, Judge.
Let's just do it one time.
I'm
Pardon?
gonna walk him out now.
Yes, go for it. Okay. I know I got my. Court does call the case of the people versus Andrew Krupa.
On behalf of people.
Good afternoon, Judge. Joshua Van on behalf of Mr. Krupar, who's present to my right as well.
Your name, sir?
Andrew Stevens, Krupar.
All right, what are we doing on this today?
Now the courtroom shifts into a completely different matter, and the mood changes fast. The first case had uncertainty around testing and compliance, but this next case starts with procedural confusion. A new file, a physical complaint that has not fully made it through the building, and defense counsel trying to understand exactly what is being addressed. That might sound boring for a second, but this is actually how serious cases begin to unfold in real time. Before anyone argues guilt or innocence, the court has to know what charges exist, whether the defendant has been arraigned properly, whether formal reading is waived, and what schedule controls the next hearing. Judge Simpson's question cuts through all of that. What are we actually doing here? That is the court trying to organize chaos before making decisions that can affect someone's freedom, bond, and next court date.
Your Honor, we have a couple of things. First is arraignment, if Your Honor is looking to do that on his file. But basically, we had a complicated situation where MSP swore to a new case a 15 file yesterday, but it was a felony case. The physical file hasn't made it to this building.
Right.
So I engaged in making a makeshift court file.
Yeah.
We will need to and I otherwise understand that we have another matter that needs to be addressed as well.
Yes. Is he, have you seen a copy of the,
I haven't, but we've been I know that the Bain charges, but no, I have not yet seen a copy.
He's charged with 8 counts.
Okay.
The most severe, is the smaller from the. Yes.
Yeah, we just cleared that today.
Okay, that's why the officer's standing behind them.
Yeah,
because
no
it's
problem.
showing-
Yep, we cleared it this morning, no problem. Perfect.
all right,
I have,
did you wish-
sorry,
did you wish for me to formally read the complaint to you?
no, Judge, I would waive the formal reading. Thank you. We stand mute and ask that you enter.
Defendant having waived formal reading standing mute, the court will enter a not guilty plea. I don't really have a case number to call off of this yet. I'll call it by the. I even have a report number.
I can give you the form.
You got a case number? Yeah, go ahead.
24F55689.
Got it. Got it. Actually, it's on the print. Thank you, Emily. All right. Defendant having waived formal reading standing mute, court will enter a not guilty plea. It will set a probable cause hearing in this matter. Defendant demanding same for the November 14th.
At this stage, the court is handling the formal structure of the case. The defense waives formal reading, stands mute, and the court enters a not guilty plea. That is not a dramatic confession moment. It is standard procedure. Standing mute means the defendant does not personally enter a plea, so the court enters a not guilty plea on his behalf. Then Judge Simpson moves to set the probable cause hearing, which is an early stage where the prosecution must show enough evidence for the case to continue. But immediately, scheduling complications appear because there is another case already set. This is where viewers need to pay attention. Multiple cases create multiple layers of risk. One date can affect another. One warrant can complicate another bond argument. And when a defendant has several open matters, the court is not just looking at one snapshot. it starts looking at the entire pattern.
So where,
Judge, can I
Yes.
interrupt?
go ahead.
There's a case that's in Macomb, I know that you're about to address as well. That case is also set on November 14th. I'm happy for this one to take priority, but I just wanted to let you know there's also a hearing on that.
Well, I'll set this one then for November 21st,
Thank you, Judge.
2024. I don't think this is the right format, but that's okay. I'll take care of it. It's at 9 a.m. Has to bond in this case.
The request be taken into custody and that his bond be set at the amount of 150,000 cash surety. The defendant, count one, is facing up to life in prison for trafficking of over 1,000 or more grams of cocaine. This defendant came into under investigation by the Michigan State Police when federal authorities determined that he had been trafficking drugs internationally from Europe as well as interstate many times from California. Engaged in an illegal contract with younger people. He paid them about $100 to $200 per package and said, can I have these packages delivered to your home? And let me know when they're there, I'll come pick them up from your porch. He did this numerous times, further, including at least 10 times from California. The feds then intercepted a package that they determined to have MDMA in it. This then led to a search warrant where the package was successfully under surveillance delivered to the home, and the Michigan State Police, and specifically LawNet, began an investigation into Mr. Krupar. Once the package was delivered to the home, the person who was supposed to notify him that the package was there did so. Mr. Krupar arrived, took the package, and the police attempted to arrest him as well as execute a search warrant on his home. When they executed a separate search warrant on his home, there was a great deal of controlled substances that were recovered, over the 1,000 grams of cocaine. There was separate drugs that were recovered from his vehicle as well.
Now the prosecution's bond argument comes in heavy. The allegation is not just simple possession. The prosecutor describes an international and interstate drug trafficking investigation. Packages allegedly coming from Europe and California. Younger people allegedly being paid to receive deliveries, intercepted MDMA, surveillance, a search warrant, cocaine, and additional drugs from the vehicle. That is a serious escalation. When prosecutors argue bond, they are not trying to prove the full case beyond a reasonable doubt at that moment. They are trying to convince the judge that the charges, alleged conduct, public safety risk, and flight risk justify restrictive conditions. And here, the prosecutor is building a narrative of scale. Not one mistake, not one bad night, but repeated alleged activity. Be honest, when a bond argument includes international packages, controlled deliveries, and large quantities of drugs, does a low bond still make sense?
Notably, though, while the penalties, unfortunately, for resisting obstructing the police are just not as substantial, although they should be, when the police attempted to take him into custody, he attempted to flee. He ran from them and he resisted arrest. So not only do we have a person before Your Honor that has been engaged in international drug trafficking, he has, this is a 2021 case that is not at the fault of MSP. This is a case that once the federal authorities are involved, it takes a very, very long time for it to be processed. As soon as MSP was able to enter this into on-base, they notified me immediately and I was able to bring the charges before Your Honor. This defendant, notably, is also before Your Honor on our other PCC case. Mind you, that case is not as substantial in terms of penalty, but in 2024, which is the case he's otherwise here before Your Honor, he's otherwise in possession of cocaine and just over $9,000 in cash that we understand to be the proceeds of drug trafficking. That's on the other file that's scheduled for PCC today. Similarly, the warrant that I understand defense counsel may indicate to the court has since been cleared perhaps today, but the no bond warrant that was out for his arrest today was for a CSC case in Macomb. He also has another case, I believe it's, I'm going to say it wrong, something about Chippewa.
Oh, is it?
Is that the jurisdiction?
Isabella County.
Isabel, thank you. He has another case that came under investigations, frankly, from drug trafficking, but resulted in a malicious destruction of property or some charge along those lines that he's otherwise dealing with. So while this case is from 2021, it's not as if he's had his hands clean since then. Instead, he has picked up numerous other cases in the CSC case, and he has also previously been prosecuted for CSC in our county. So, Your Honor, at this time, our prosecution bond is set at $150,000 cash.
Yes, sure.
The prosecution has asked for a $150,000 cash bond, and now the defense gets its turn to push back. This is where bond hearings become a tug of war between danger and due process. The prosecutor frames the defendant as a public safety concern with multiple cases and serious allegations. The defense now has to humanize the situation and narrow the court's focus. Defense counsel starts by working backward, explaining that one warrant was allegedly tied to confusion over dates and had been cleared earlier that day. He also says the apparent CSC case is expected to resolve differently, with those charges dismissed and a plea to a drug-related count instead. That distinction matters because the label of a case can sound more severe than the expected resolution. Still, the challenge is obvious. Even if the defense explains one issue, the judge is looking at all the issues together.
So I'll work my way backwards a little bit here. The charges in Macomb County, he had a failure to appear on a confusion on dates. We went to the Judge Julie Gotti this morning before we came here, Judge. Actually, this afternoon at 1:30, we appeared before her. She set aside the bench warrant. That case, while it appears to be a CSC case on paper, the CSC charges will be dismissed on November 14th, and he'll end up pleading to a one count of use of analogs. So just so we're clear on that, as far as the case that he picked up here, the 2024 case, obviously we were before this court. He appeared before this court every time. He has a bond on that case that this court gave him. This 2021 case is not something that he has run from, despite what may have been, I guess, I'm not saying any false statements were made by Ms. Hughes at all. I'm saying there was an attorney that was involved earlier on with the forfeiture part of this case. And he has been there and has had that attorney until he's now hired me to address this case when it came up. Knowing this case was coming up, Ms. Hughes was kind enough to tell us last time that she was going to be authorizing the charge. He's still here and showing up for court. He has a tether on his ankle right now, and he shows up for court when he's supposed to be there. That may sound undermined by the fact that they issued a bench warrant in Macomb County. Honestly, Judge, it was a confusion of dates, and we cleared that up today. He's got other matters that are going on in Isabella County that he's resolving, and there have been no issues as far as his failure to appear or anything like that. So at this point, Judge, I understand the nature of the charges. I'm at a bit of a disadvantage factually because I don't have any discovery, nor should I at stage, I guess. So I'll make sure to get that. But this is 2021, and he's here and been here. I think I know he'll be here again in the future. He's got a tether on so the court can keep an accurate, oversight of him. I have a feeling that the case in Isabella is going to end up resolving with jail time up there, so he's not going anywhere on that one either.
What court is that out of?
That is out of the Isabella County Circuit Court. I'm sorry, I don't know the number, Judge.
Here, defense counsel keeps trying to stabilize the picture. He argues that the defendant has been appearing in court, has a tether, and is not running from the 2021 case. He also explains that the Isabella County matter is moving toward sentencing, meaning the defendant may already be facing jail time there. That argument is strategic. If someone is already under supervision and already tied to other court proceedings, the defense can argue they are not likely to disappear. But Judge Simpson immediately starts probing the details because vague reassurance does not carry much weight when warrants and multiple counties are involved. This is where bond hearings become extremely technical. It is not enough to say he is handling it. The court wants to know what court, what case, what warrant, what date, and whether anything is still active. And that precision can make or break the argument.
Do you know the number?
Maybe 30. Oh, you know what?
Does that include Mount Pleasant?
That is Mount Pleasant. Yes.
Got it. 21st. Well, you're saying what's going on with that case?
He's being ready to be sentenced on that case. I know the sentencing date is getting, I think, selected, but he ended up pleading to drug charges up there, which his guidelines.
Well, there's a problem then. Are you handling that case?
Yes.
Because there's a warrant for him on that case.
And all I knew is that when we went to the sentencing last time, the judge was going to hold the warrant until we can get resentencing done on him. So, and that's because of the confusion on the.
Well, when was that?
It wasn't within the past week or two. It was, I think it was the day after we were in court here last time.
Because I've got a warrant date of 10/18/24.
We've been to court since then. I think when we went to court since then, a PSI was issued. And I think that's why, yeah, the PSI issued on 10/14. The warrant, there was the warrant for the failure to appear on 10/18. And I think we went back before the court either on
You're
21.
saying they didn't cancel the warrant?
I didn't know the warrant had issued. I know the judge initially said he was going to hold the warrant. I didn't know that the warrant had ever actually issued. Maybe it issued.
I've got a warrant for, what do you got?
Which one are you looking at to confirm the Mount Pleasant one?
I've got a warrant that indicates it was issued on October 18th, 2024 out of Mount Pleasant. On a charge of destroying evidence. And it says hold with no bond.
That line is a courtroom bomb. Judge Simpson finds a warrant out of Mount Pleasant connected to a charge of destroying evidence, and the warrant says hold with no bond. That changes the entire bond discussion. A no bond hold means another court may already have determined that release is not appropriate in that matter, or that the defendant must be held until that court addresses him. Defense counsel does not try to fake certainty here, which is smart. He says he does not want to speak incorrectly to the court. That matters because once the judge finds an active hold, the defense's earlier argument about compliance starts losing force. Even if one warrant was cleared, this one apparently was not. And for Judge Simpson, this confirms the concern that the defendant's legal situation is not controlled, not simple, and definitely not clean.
Part of the, I know he was charged in one of the charges with tampering with evidence, so it's part of the same case. Why we would only issue on the one charge. I know that I appeared after that and the PSI was being updated, which it did, and we're waiting for the sentencing date, but maybe it didn't get set aside, or I don't want to speak on it because I don't want to say something wrong to the court. My understanding was the judge initially issued a warrant because there was the failure to appear, but he held the warrant without entering.
I don't
Now it's entered,
know.
apparently.
It's entered. It's been entered since the 18th of October and not cleared. And
I understand the ramifications of that, which is why we cleared a different one today. And had I known about it, I would have tried to make sure it got taken care of before today. Unfortunately, didn't know about it.
anything else? I
Um,
mean, I got, part of the problem is when I look at these dates of offenses, I would tend to agree with the people that this one's a 2021, his behavior exacerbated itself in a certain respect because got that, and then from 2001, and then the current case that I have, understanding what the people are saying about what he was found with that led to the current charges is extremely troublesome to me. It's also extremely troublesome that the drugs involved in the, if true, that paying young people to transport, in essence, cocaine, methamphetamine, and fentanyl, well, is hugely problematic for me.
Judge Simpson is now spelling out why the allegations trouble him. He is not just reacting to the drug charges in isolation. He is focusing on the alleged use of younger people to receive packages, the types of drugs involved, the later possession allegations, the cash. the warrants, and the broader pattern. This is important because bond decisions are about more than whether someone can pay. They are supposed to consider public safety, likelihood of appearing, the seriousness of the charges, and the defendant's history. The judge's concern is that this does not look like one isolated incident from 2021. It appears, based on what is being argued, like the defendant has continued picking up cases. That is why the defense's "he shows up" argument only helps so much. Showing up matters, but if the court believes the person remains dangerous, appearances alone will not carry the day.
And then being found later with drugs and a large amount of cash, and then having these other charges where there are warrants and he doesn't seem to deal with what he needs to deal with. So,
And Judge, I agree with everything. Not that you're asking me to agree. I just want to make sure you know, had we known about that other warrant, I would have came into this court, made sure it was taken care of. But I understand completely the court's concern. I know the prosecutor's asking Judge for 150,000 cash surety. The only thing that I would ask is if you could add a 10% provision, tether provision. I'm not even sure you can post that, but if you could.
well, I don't, quite frankly, I understand what the people are asking for. I don't think that's quite frankly a high enough bond. I mean, I think that this individual is a very dangerous individual, sort of spewing poison out there into our communities, at least as it's alleged, and then doesn't seem to learn his lesson and then is caught again. And I have very serious concerns. If he's walking around with $9,000 in cash on this, after he has that I've got a case that, at least in terms of some evidence, it's alleged at least that he's destroying. And then there are other charges kind of all over the state of Michigan. This person seems to me to be not only dangerous to the community, but it certainly poses, as the court views it, a flight risk in terms of having the ability to take off. And anything else you want to say before I set bond?
No, Judge, and frankly, looking at the charges and everything that you're looking at, I certainly understand where the court's perspective is from. The only thing I would remind the court is he knew about these things coming and he still has been here. Again, the court, I know, considers that it's just a small portion of its consideration. That's all.
If the defendant does post the bond in this case, then he is to be placed back on, if that tether is removed, he's to be placed back on a home confinement tether. If he were to post this bond, I'm going to set his bond. And what are we doing on this case that's before me today?
Now, Judge Simpson starts laying out conditions in practical terms. If the defendant somehow posts bond, he must be placed back on home confinement GPS tether if the current tether is removed. That is a major restriction. A tether is not just a decoration on the ankle. It is a monitoring tool meant to control movement and reduce flight risk. The court is also dealing with the separate case before it, pushing scheduling together so the matters can be handled more efficiently. Then the prosecution asks for no contact orders, which adds another layer. No contact orders are direct court commands. Do not contact the named people directly or indirectly. Violating them can create new trouble fast. So at this point, the defendant is facing bond pressure, GPS monitoring, multiple court dates, possible holds, and no contact restrictions. This is not a simple release situation anymore.
So until I get the discovery on the new case, Judge, I would ask that it be adjourned together, if that's okay.
I'll adjourn that out to November 21st, 2024 at 9 a.m. or as it indicates. Bond on that matter will continue. Yes, Ms. Hughes.
Can I ask for a no contact order as well? There's one for Catherine Davis. If I could request a no contact order for Catherine Davis.
No contact with Catherine Davis.
And then could I also request a no contact order with Kaylee Aldridge?
Give me a spelling.
Aleigh Aldridge, Aldridge. And then we could have.
And the Catherine is spelled which way?
Catherine is Kathereine.
And what was the last name? Sorry.
And finally, we could have.
Davis was the last name.
Put his current address on the record.
There's been an anticipation with the other case, Judge, that he wouldn't be able to stay anyplace long because if he's going to be incarcerated, there wasn't really a reason for him to establish a more permanent residency. So that was the only issue. I'm not sure if that's the entirety of it, but I want to make sure the
All
court.
right, I will under no contact with Catherine Davis, Kaylee Aldridge. As indicated that if the defendant posts the bond I'm about to set, then he is to be placed on a home confinement GPS tether. And at this point, until I can, I certainly will take a look at it, but looking on the face of this with everything else that's going on and having a no bond hold in Isabella County or Mount Pleasant, the court in this case is going to set his bond at $500,000 cash surety. Defendant is remained.
Understood, Judge. And obviously with that no bond hold anyway, I appreciate it. Thank you for your consideration. And if I need something in writing after I get the discovery, I'd appreciate that. Happy Halloween.
And there it is. Judge Simpson sets bond at $500,000 cash surety, far above the prosecution's original $150,000 request. The ruling reflects the court's view of the alleged danger, the serious drug trafficking accusations, the cash, the multiple pending matters, the unresolved no bond hold, and the broader concern that the defendant poses both a community risk and a flight risk. The court also orders no contact with Catherine Davis and Kay Aldridge, and if bond is posted, the defendant must be placed on home confinement GPS tether. The key takeaway is sharp. In bond court, the judge is not just listening to one case number. He is weighing patterns, warrants, public safety, and whether the defendant's legal situation shows control or chaos. What do you think? Was $500,000 cash surety justified here, or did the court go too far? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.